I say this to not just global institutions and multilateral agencies, but also local private sector Kenyan civil society groups and others. The coalition has given me an honor of working with leaders like President Lula of Brazil and Emmanuel Macron of France, together with Alex from Finland. These are great leaders whom I appreciate what they do, and to them and commend them in particular, and especially Brazil's G20-led Global Alliance Against Hunger and Poverty. Kenya calls on other nations to join in this shared quest to ensure no child is left behind. Let me also say this, that it is not possible for us to discuss school feeding in isolation. As part of making sure that all our children have access to food, we have scaled up as a government our agricultural intervention to provide and supply more food in Kenya, so that we are not just addressing issues about our children, we are addressing issues about the people of Kenya. It is that we have done three things in our agriculture. Number one, we have gone back to supply subsidized fertilizer to our farmers. And I'm very proud of what the farmers are doing. It is the reason why the staple food in the last 2 years has come down by half. What was being sold for 230 shillings is now being sold for 100 shillings. Number two, we are expanding our land under irrigation because we realize that with climate change, a much more predictable food system must be on irrigation. We have 700,000 acres under irrigation at the moment. By 2027, we want to increase that by another 500,000 acres. And by 2032, we want to take it to 1.8 million acres to make sure that we sustainably can feed not just our population, but also our children. And thirdly, we are also making sure that we provide offtake for our farmers so that we can encourage them to do more and to make sure that we are moving in that direction. And apart from feeding our children, very important for our children, education and health. This is the reason why we have now expanded under the Universal Health Coverage Program what was Edu Afia, which was meant for secondary school children. Under Universal Health Coverage, we have now expanded that program to include not just children in secondary schools, but all children in primary schools and all children above the age of 5. That way, all our children have access to insurance to make sure that their health is taken care of. And number three, on education, because we want all our children in school. I will be meeting the County of Nairobi members of parliament and leadership to discuss education in Nairobi, because we have provided 1 billion shillings to do 1,000. Our intention is to provide another 5,000 classrooms in Nairobi County, because we want all our children in class. There are informal schools. And the informal schools, although they are great initiative, but they do not have the kind of infrastructure that will equalize the fortunes of all our children. We want all our children to learn in the best environment that is possible. It is also the reason why in the last 2 years, we've hired 56,000 teachers more. And next January, we are hiring another 20,000 teachers so that every child in our schools have access to a teacher and they can learn. It is also a moment that even as we move into grade 9, we've not only finalized the process of building an extra 11,000 classrooms as government. I've also asked our members of parliament, using their constituency development fund, to also build another 6, so that next year,
I served at East Park as the head of legal, and now I know there are about 24 or 27,000.
and I am very happy to announce that we have already made all the learning material available. There will be a book, every subject for every learner, to make sure that our transition is complete and our transition is effective. So as we discuss, we're discussing the health of our children, and we are discussing the education of our children. Are a blessing to us as families, as parents, and as a nation. And as we look after them, we ensure our future. It is the insurance that we have for our future, including the World Food Programme, World Bank, Global Partnership for Education, and the governments of the United States, France, Germany, and China for their steadfast commitment. With this unwavering support, we are better positioned to pave the way to a future where every child is nourished, empowered, and equipped to grow, succeed, and be the best that they can ever be. And we give a chance to every child, as was said earlier by the earlier speakers. So let me say thank you very much for coming for this meeting. It is a meeting that is emotional for me. It's a very important meeting because we are not just discussing the present, we are also influencing the future and how that future comes out. And I want to ask all of us to provide whatever support that contributions in ideas, in innovations, and in whatever support we can, to be able to make sure that we all succeed. Thank you very much, Cindy, and your team for finding time to come.
I've had with professionals for a long time.
And this speaks to the heart of
From the rural setup like myself.
as a country. Thank you very much.
To go to our rural homes. It's a plan because we only go in December to showcase your new Mercedes Benz. To interact with your relatives. To showcase how.
Of course, we apologize for that technical glitch at the end. That was President ministerial meeting on the Global School Meals Coalition here in the capital, talking more about in terms of the irrigation that is being undertaken by the government. He clearly stated that currently 700,000 acres is under irrigation, and the government is seeking to increase that acreage to at least 1 million. He has also quickly touched on the Edu Afia for Children, an insurance scheme that will be under the Social Health Insurance Authority, that is SHA. And of course, the president clearly stated that the government will also be issuing at least, currently they have issued R1 billion to build classrooms here in the capital, to of course decongest some of the classrooms within this particular capital. And of course, clearly stating that another additional 5,000 classrooms will be facilitated to the capital. He clearly stated that he will be meeting with the leaders, including the Nairobi Governor Johnson Sakaja and other leaders within the capital, to ensure that all learners get access to education. And of course, he clearly stated that meeting will be done in the coming days. The president also touched on the number of tutors that have been so far hired since he took over office. That is 56,000 teachers, and he clearly states that by January 2025, an additional 20,000 more teachers will be hired. And of course, reiterating what he said during the weekend, that 11,000 classrooms will be built across the country to facilitate grade 9 students. But for now, we want to take you live to the proceedings that is currently happening at the Milimani Locus, and we'll be giving you that particular feed in just a few. what the arguments that were being made before the court this morning, spearheaded by Paul Mwite, who is representing the impeached Deputy President Rigathi Gachagua, is on the conservatory orders, where the Attorney General, that is Dorcas Oduor, is seeking a stay of that particular conservatory orders that has seen the prohibition of the swearing in of Deputy President nominee, that is Professor Kithure Kindiki. Now, the petitioner argues in this case, that is impeached Deputy President Rigathi Gachagua, that they will be basing their case on three fronts. That is public participation, clearly stating that the public participation was not adequately done in terms of the constitutionality of the 12th day of conducting the impeachment, clearly arguing that the speed at which the Deputy President was impeached was in question, and then finally the threshold of the burden of proof. Those are the three arguments that are currently making, and as and when we get those particular live images, we'll be taking you there. But we want to take you back to Mombasa, where the IEK, that is the Engineers Convention, that is currently happening at the coastal city. Let's continue listening into the proceedings that are happening there in the coastal region.
That is the greatest risk professionals are holding. We believe it's my neighbor and not me. We as professionals must change our attitude and help the country breathe by being the proper champions of change with the correct information, analysis, data, projections. The same things you do while you're designing a building. The same things you do while you're advising on brick and mortar. It's all about life, our life experiences, and the changes we want to make. What really is our role in the contribution to the country's development? If professionals are not leading, we shall be led by non-professionals. We shall be the menu that is being served. In that case, allow yourselves to be eaten while well cooked. You can clap. Kenya, like many other African nations, is poised for significant industrialization and green growth. The question I ask, where is the seating of professionals? The rise of automation and artificial intelligence is expected to transform various industries. While this presents potential job displacements, it also opens up new opportunities for skilled workers, especially in science, technology, engineering, technology fields. That's the STEM. We must create innovators. Our curriculum for a long time did not fashion our brains to be innovators. We must change it. Despite the increasing demands for STEM skills, women and the young people remain underrepresented in these fields in this country and Africa at large. Addressing these gender gaps is crucial for tapping into the full potential of not only female workforce, but the youth. Studies have shown that countries with greater gender equality tend to have higher economic growth rates. If you leave half of your population out of decision making, you've left half of your potential. Transition to a green economy will help create new job opportunities for women and youth, particularly in sectors like renewable energy, sustainable agriculture ecosystem, and construction. By empowering women and the young people to participate in these sectors, Kenya can harness their potential to drive sustainable development. You'll agree with me that women and the youth bring diverse perspectives and innovative solutions to the workplace, fostering a more dynamic and productive environment. Women are often at the forefront of sustainable initiatives, making them valuable assets in the green economy. Unfortunately, as we continue to face significant barriers, including access to education, leadership positions, access to finance, and employment opportunities, they also experience discrimination, violence, harassment at the workplace, hindering their professional advancement. Africa faces significant infrastructural deficits, including transportation and digital connectivity. This hinders industrial development and competitiveness. A lack of skilled labor, particularly in technical and managerial roles, limits the ability of African countries to attract investment and drive innovation. So how do we overcome these challenges? It is by fully realizing the potential to harness the power of all. Investing in women and the young people through education and skills training is crucial for their economic empowerment. It is also about recognition and redistributing of unpaid care work. By providing affordable and accessible childcare, we will help women balance work and family responsibilities. For those in formal employment, implementing friendly work arrangements such as remote working and flexible work hours can accommodate women's diverse needs in the society. Mentorship and sponsorship programs also help women and the young people advance their careers and reach leadership potential. At the same time, government policies and legislation promoting gender equality and women's empowerment in the workplace are in place to create a more favorable environment for women engineers. I call on the private companies to implement policies that support women's advancements such as flexi work hours, equal pay, diversity, inclusion, and training. Enacting and enforcing laws that protect women's rights and promote gender equality is essential. Encouraging public partnerships is also key. My office is collaborating with the World Economic Forum to establish the first gender parity accelerator in sub-Saharan Africa. By focusing on women-owned micro, small, medium enterprises, we can create tailored support mechanisms that power women entrepreneurs. You can clap. Our office also participated in shaping the World Bank gender strategy for the next 4 years, and I can assure you within this space, the agenda for the women and youth was well captured, with World Bank setting aside $25 million for women-led and youth-led projects. You should clap, because that's where you should go and get. So the accelerator then will not only enhance access to resources and funding for women-owned businesses, but also foster innovation and sustainability within these enterprises. In close collaboration with the private sector, we can create more jobs for women and youth and promote gender-inclusive practices, driving economic growth and social equity. Allow me to say that Kenya is a patriarchal society, so is Africa at large. You'll be surprised it's a global problem. So we must challenge any cultural norms and practices that disadvantage women and the youth participation in the economic development of our countries. Traditional gender roles need to be interrogated, and gender equality in societal norms mainstreamed to leave no one behind is very important. Collecting and analyzing data on women and youth participation in the workforce will enable the enactment of informed policy decisions and policy direction and subsequent tracking of progress. Benchmarking by collaborating with international organizations. Countries should be encouraged to facilitate knowledge sharing and good practices. Embracing technology will enable us to improve productivity and competitiveness. We must ensure timely enactment of legislation, policies that promote technology transfer and innovation to address the slow adoption of technology in African industries, and professionals must participate. While Kenya has made strides in promoting gender equality in various fields, engineering remains a male-dominated profession. However, a growing number of women are breaking down barriers and making significant contribution to this field. I'm happy to note that the Institution of Engineers of Kenya Women Engineer Chapter provides a platform for women engineers to network, share experiences, and advocate for their rights, and today's summit is one such avenue, and I must say, well done to the leading teams. To encourage more women to pursue engineering careers, it is essential to promote STEM education for girls. Experience has shown that early exposure to STEM subjects sparks interest and inspires young girls to pursue engineering. However, traditional gender roles often discourage girls and young women from pursuing STEM fields, leading to a lack of female role models in engineering. Providing mentorship and sponsorship opportunities also helps in advancing their careers and overcome challenges. The government, through relevant ministries, has undertaken initiatives aiming at inspiring young girls to pursue STEM careers, such as the STEM camps, workshops, competitions to encourage more women to enter these fields. Empowering women has many advantages. It leads to increased labor force participation, expanding the pool of skilled workers, and boosting productivity. Specifically, women's economic empowerment leads to increased households' income, improving the overall standard of living and reducing poverty rates within the society. When women have access to resources, education, and opportunities, they can start businesses, create jobs, and drive economic growth. Universally, women's empowerment is linked to better health and education outcomes for their children, leading to a healthier and more educated workforce. Remember, when we speak about women and we bring children, we are talking of both boys and girls. The young men in the room, you should clap. Young people, on the other hand, are often at the forefront of innovation and entrepreneurship, driving economic growth and job creation. Investing in the youth education and skills development creates a skilled workforce that meets the demands of modern economy. Empowering the youth reduces poverty and inequality by providing them with opportunities to secure decent jobs and improve their livelihoods. Empowered youth are less likely to engage in crime and violence, contributing to a more stable and peaceful society. Gen Z. To harness, they are here. To harness the potential of women in industrialization and green growth, policymakers should prioritize STEM education and vocational training to build a skilled workforce. We must be deliberate and prioritize mentorship for young engineers. We must leave a legacy. We must grow potential. President, what legacy will you leave? Who are you mentoring to be the next president? Let us continue encouraging public-private partnerships in our countries to create job opportunities for women and to promote gender-inclusive practices. Similarly, creation of a supportive ecosystem for innovation and entrepreneurship must be prioritized. Let us spread our wings to go global, learn and unlearn, tap into the new areas of engineering, and cut a niche for ourselves. Africa will unlock its industrial potential and achieve sustainable economic growth by empowering women and the youth. Embracing their potential, Kenya can position itself as a leader in sustainable development and economic growth. The true value of smart cities lies in the ability to foster innovation, sustainability, and inclusivity. While enhancing the well-being of its citizens, smart cities are not built on brick and mortar, but with data and innovation. I now declare this conference open. Thank you very much.
The 31st International Convention of Engineers that is currently happening in Mombasa. Of course, that was the guest of honor, the Cabinet Secretary for Gender Affairs within the administration. That is Ms. Harriet Chigai addressing the engineers there. And of course, we want to take you now quickly to the Milimani Law Courts, given that that is our main priority this morning. And of course, it is in terms of the case against the impeached Deputy President Rigathi Gachagua. What the lawyers now on the defense side are arguing is on the conservatory orders. There you can see Wakili Masharia speaking. Let's head over there.
The Wambora decisions where the court, both the Court of Appeal, went to great lengths to explain where you draw your jurisdiction from. So I believe the Supreme Court decision in the Sonko case should put to rest the question as to whether you have jurisdiction even on political questions. The respondents then make another submission. This is that this court lacks jurisdiction to interrogate the presidency for elections lies exclusively of Kenya. They don't say so explicitly by way of example that under Article 164, Article 163, sub-article 3A, the exclusive original jurisdiction to hear and determine disputes relating to the elections to the office of the president arising. It's it's important to linger on every of those words. The exclusive jurisdiction is limited to elections, number one, arising under Article 140. And there's a reason it's worded this way, and here's the reason. Now, not every election is a presidential election. Now, under the definitions set out under the Elections Act, the Elections Act is itself a statute promulgated by Parliament under the provisions of Article 82 of the Constitution of Kenya. It recognizes only 3 types of presidential elections. The first is Article 136. It is that election that leads and that has the qualifications and the mechanism for it under Article 138 that then leads to a petition in the Supreme Court of Kenya under Article 140. There is then another election under Article 139, sub-Article 1B, and you will find this in the definitions of the Elections Act. And the third presidential election understood is Article 146, sub-Article 2B. A replacement of a deputy president under Article 149 is not an election. And I must confess that Article 149 was perhaps not worded very elegantly, because what Article 149 does is that Article 149 almost seems to have ended prematurely, because it says within 14 days after a vacancy in the office of the deputy president arises, the president shall nominate a person to fill the vacancy. So it's a nomination. The word used there first is nominate. A person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. It doesn't say anything after that. But one of the things I found when I examined another statute with similar provisions, this is Section 32D of the County Governments Act. Section 32D of the County Governments Act is actually a lot broader. It explains how that vote will be conducted, the time periods for it, the threshold for that vote. It's a lot more elaborate. But one of the things it makes clear is that the vote akin to Article 149 is an approval. It's not an election. It's an approval. And if one were to examine the Constitution further, everywhere the word election is used, and just by way of a few examples under the Constitution, Article 86, Article 87, Article 83, all of those articles, including the powers and functions of the IEBC, which my learned friend Mr. Ndegwa will be speaking to later, all of those make it clear that the election contemplated is a contested election with voters under Article 1. 14 million Kenyans. That is what the Constitution understands as an election. That then invites the jurisdiction of the Supreme Court of Kenya under Article 140. So it cannot be that the respondents get to make 2 opposing arguments. They argue that because this is their argument, this is an election, so you can only go to the Supreme Court of Kenya. But they then argue this is not an election that requires the IEBC. That's one of the things they've argued. Because an election requires the IEBC, as properly understood. So even that argument, one that has the repository of jurisdiction to determine this matter, does not find any basis, does not find any grounding in the Constitution of Kenya. You can also look at Article 106(2)(a) for what they discuss when they talk about an election. So Article 149(1) does not envisage any contest. The president nominates one name. And while I'm here, let me deal with an elephant that my learned colleagues will be throwing at you. It's actually more of a monster. In response to what we are telling you, they will tell you there's a public crisis of monumental proportions not seen since the late Daniel Arap Moi told us that he will appoint a vice president if it increases the sufurias of ugali in our houses. We'll be told this is the worst thing that has ever happened. There's a vacancy. Answer number one, Article 148 does not, not 148, sorry, I believe I'm talking about the sequencing where the Speaker of the National Assembly is the third in vacancy. I have been waiting for my good friend Mr. Milimo, who represents the Speaker, to shoot up to his feet and protest loudly that his client is not a vacuum. Because the Constitution says, when, I think it is, this is Article 146, Subarticle 2B. If the office of Deputy President is vacant, or the Deputy President is unable to assume the office of President, the Speaker of the National Assembly shall act as President, and an election to the office of the President shall be held within 60 days after the vacancy arose in the office of the President. Two things to note there. In that article, the framers of the Constitution contemplated a vacuum in both the presidency and the deputy presidency. And it is at this point where my good friend Mr. Anatosha. Maybe you'll say it. I am almost certain in the event that my good friend Mr. Kamodo described here a few days ago, when he said the president might go to where people don't come back from, that we will all say Wetana Tosha. He did. The record says so. Yeah, but we understood him. He was not wishing ill. So that's the first thing. The second thing, my lord, is that they contemplated we can operate for 60 days, 2 months, without either a president or a deputy president. The world will not collapse. Kenyans made adequate arrangements for the caretaker while those two are not with us. And there seems to be something magical about these 60 days that Kenyans clearly had. Because under Article 149(1), when the deputy president is impeached or there is incapacity, the president has 14 days to nominate a candidate to the National Assembly. That is number one. And because it is not obvious, or it is not a matter of course, that the National Assembly will approve that candidate, it must be contemplated that the National Assembly can refuse to vote for that candidate. So those 14 days can be repeated, which is what the Constitution says. If Parliament rejects the first candidate, the process is repeated again. And the Constitution seems to contemplate can be repeated almost indefinitely until the President comes up with a name that is acceptable. So that is number one. And there's no crisis. The world will not end as Parliament rejects those candidates. So that's number one. But the President having nominated a candidate, the National Assembly itself has then another 60 days. So we can again operate as a country for 60 days without a deputy president. And so I return to what the Supreme Court said in the Sonko case we must do and has not been done, has not been afforded to our client, the Deputy President. This is what the court says. This is the Supreme Court again. They converted the proceedings into an advisory opinion. So they're actually giving this as a template for courts, such as this honorable court, to follow. Paragraph 114. To the question whether due process was followed in the removal of the appellant, the Audi Alteram Partem rule requires that those who are likely to be directly affected by the outcome of a decision should be given prior notification of the action. So they give a whole list of what must be done. Prior notification of the action, of the time and place of any hearing that is to be conducted, and of the charge or case they will be called upon to meet. They must be given an opportunity to be heard. Now, it is not a matter in dispute that on the night the Senate, I and my colleagues on both sides were present in the Senate, our client was taken ill for good reason. So he is taken ill, and the Senate then takes a vote. And this was important because the Senate had 2 days left, even in their own self-prescribed time limits. They voted, and this was not an electronic vote, acclamation to extend time for the
learned counsel is misleading the court. And affidavit, it is clear that the Senate votes electronically. Senate does not vote. I do not. Perhaps he can point to the court addressing himself to on the question of acclamation. We can't just sit back and watch lead the court.
I was personally there. Senior Counsel Muite was there. The entire team, most of them were there. On the question of extension of time, it was by acclamation. And all the no's, that's what it was.
And the senator was loud.
Yes. And I would ask him to please wait. He'll be a bit more bothered when I finish with my submission, so he can be bothered fully when I finish. So this is what the court says. They must be given an opportunity to be heard, to call witnesses, to be represented by counsel, to be available adequate time and facilities to prepare, and if the accusations are proved, to be given the reasons. This is important. The Supreme Court says you must be given reasons for your decision. There are no reasons. They voted on the National Assembly. They did not give reasons for that decision. Of course, beyond there, they are also entitled to challenge the decision. Again, you've been told these decisions are not challengeable. The Supreme Court says the accused must have the decision against the higher court or tribunal. At paragraph 115, Article 47 of the Constitution enshrines the right of every person to fair administration. The manner of actualization of those rights have been enacted in the Fair Administrative Actions Act. Now, when this Honorable Court retires to do its ruling, I would to pay attention to sections 4 and 5 of the Fair Administrative Action Act. They're important in more regards than one. Senior Counsel Paul Muite has alluded to the question of public participation, and so will some of my colleagues who will come after me. When the National Assembly conducted what it called public participation, it did not avail to the public the response by the Deputy President. What they did is prepare a charge sheet, a copy of which you will find as Annexure 8 of our affidavit in support of the petition, which for ease of reference is at page 498. That charge sheet asks 3 questions. It first sets out the 10 grounds that the motion promoter had set out, and then asks people, do you agree that the Deputy President should be impeached on these grounds? Do you not agree? And then there was a third one, other. That was it. They were not told what his response was, nor was he given an opportunity prior to this process. Because the only way, and you'll find that this is one of the things the Supreme Court says under the Article 47 and Fair Administrative Action Act, the participants in this public participation must know both sides of the story to make an informed decision as the people who voted in this manner. The court then goes on at paragraph 116. In the process of removal of a county governor, and for this case, the deputy president, the right to fair administrative action under Article 47, and the right to fair hearing under Article 50 of the Constitution, all, and I'm paraphrasing here, to the deputy president before a decision to remove him or her from office is reached. An unfair removal is one which goes against the principles of natural justice, just like I've demonstrated, which implies that no adequate notice was given, that there was bias, and where the hearing was not fair. In our amended petition, which you will see in the fullness of time, we have given particulars of how each and every of these issues was violated. The Senate and the National Assembly, first and foremost, constricted the time allowed by the Constitution for themselves. They cut their own time short. And so no one had sufficient time to do anything. We have said they introduced new evidence as the trial was going. There was panel beating as the matter was going on. And as I've said, there was a lack of fair hearing. Though, this is Supreme Court, though a political process, impeachment is sanctioned by the Constitution and the law and is not a platform to settle political scores. This speaks to what's in a council Paul Muite said a few minutes ago. It's not an issue of ticking boxes, going into a room and saying 300 of us have said you're a bad man, you must go. You're a bad woman, you must go. You must comply with each and every of the provisions of the Constitution. Bearing in mind that the removal architecture in the Constitution, the law, and the standing orders are designed to achieve accountability, political governance, and personal responsibility, and are not aimed necessarily to find criminal responsibility. On the question of natural justice, this is what, this was a decision by, I believe, your brother, Justice Odunga. It's in our list. This is miscellaneous civil application number 266 of 2017. He cites at paragraph 69 a case, I believe, from Uganda. It is a cardinal rule of natural justice that no one should be condemned unheard. Natural justice is not a creature of humankind. They are asking you to take away a creature, and let me read to you what it says. It was ordained by the divine hand of the Lord God. What God has given us, do not allow these respondents to take away from the deputy president. And that any law that contravenes or offends against any of the rules of natural justice is null and void and of no effect. The rule, as captured in the Latin phrase audi alteram partem, literally translates into hear the parties in turn, and has been appropriately paraphrased as do not condemn anyone unheard. That is what the Senate did to the deputy president. You cannot allow their resolution to stand. There is a decision, I will not read this for you, but this is a decision of the High Court, a 3-judge bench, Republic versus National Land Commission. I believe this is miscellaneous application number 266 of 2017. At paragraph 109, the decision of the Supreme Court of Kenya in Speaker of the National Assembly versus Attorney General and 3 others, where the court again restated, the Supreme Court, your jurisdiction in these circumstances. And then to the Senate proceedings I've just read out for you. In the Wambora, in the Martin Wambora case, this is what, this is the case, this is, it's cited in the Mike Sonko Mbuvi case versus Clerk of the Nairobi County Assembly. At paragraph 226, I believe this is the High Court decision, this is what the court said about what my good friend Professor Ojenda was getting a bit hot under the collar over. Although it does not fall within our remit to direct the legislature on how to perform its functions, we are of the considered view that impeachment of a governor is a serious undertaking, just like a deputy president, as the end result can lead to the removal of a popularly elected governor. The deputy president before you and the president who ran 7 million people in this country out of 14 million people who participated. It's a very serious matter. For this reason, we recommend that it will be desirable that future impeachments proceed through the committee route as opposed to the plenary. This is what the court is saying. We say so because when the special committee is appointed, it has 10 days to deliberate on the matter, thus giving ample opportunity to the parties to adequately prepare their cases. The Senate chose not to avail itself of this constitutional mechanism. The committee gives the perception that each member is actually engaged in the process as opposed to the plenary. The trial of the deputy president was held entirely in plenary. And a lot of things, when you look at the Hansard, for example, there was a lot of issues raised about a will, about a succession matter that has nothing to do with the Constitution of Kenya. When you look at the Hansard, a lot of things that had nothing to do with this constitution, and here's the problem. The committee gives the perception that each member is actually engaged in the process as opposed to the plenary, which can be perceived to be a mob lynching process, which is exactly what happened. That is our submission before you. It is what my late member of parliament from Kangema, the late John Joseph Kamotho, used to call kura ya makelele. Now, under the grounds for granting a conservatory order, one of the issues the court is called to look into is the question of whether the orders or whether the hearing will be rendered academic or nugatory. Now, at paragraph 20 of our supplementary submissions, which are dated 28th of October, 2024, we have cited before you a case by the Court of Appeal, Attorney General versus Matindi, and 55 others, where the court explains the following. A successful appeal is not reduced to a mere Pyrrhic victory or paper judgment. Whether or not a matter will be rendered nugatory is determined on a case-by-case basis, depending on the peculiar circumstances of the case. But ordinarily, the court will grant relief if what is apprehended cannot be undone once it happens, or cannot be undone without of damages. The court takes into account the respective hardship that grant or refusal of relief is likely to wrought on the parties. I want you to take my colleague. You cannot undo. Once a new candidate for deputy president is nominated and sworn in, they say the court has no jurisdiction to undo that appointment. This is what they're telling you. You cannot undo a deputy presidential nominee who has been sworn in and has taken office. This is what they're telling you. At any length, they tell you, this is a political question, don't even look at it. That's why they began. Don't even look at this. The president knew what he was doing, take him at his word and at his actions. So that's one side of the balance of the scale. On the other, you have a sitting deputy president who is before a court of law, as he ought to be. If in the unlikely event his petition were to fail, all he does is go back home and we swear in the new one once the petition is dismissed. But conversely, if you swear in a new deputy president, you kick in motion a whole series of events, including a president, a deputy president, who is now exercising constitutional mandate, who is chairing cabinet committees, that may ultimately be found to have acted outside the Constitution of Kenya. The balance lies in granting conservatory orders so that we can do this in a civil manner. Former Supreme Court judge of the Supreme Court of Kenya, Justice Ojwang, used to call a pacific resolution of the dispute. As I said, the Constitution has given ample time for all of us to interrogate these questions. 60 days is the magic figure the Constitution gave us. Let's not be in a rush to undo the timelines given to us by the Constitution. And finally, the decision of, I believe, Gachagua Munya, the question of the public funds that are expended, swearing in a new deputy president, getting him a whole fleet of cars and workers, and the trappings of power, and as is the custom, perhaps even doing the road to his village home, all these sort of things. So let's hold our hands until we can determine whether the process that led us to this day was done constitutionally. That is the Peter Gachagua Munya decision. My lords and your ladyship, the decision you make in this matter will echo in eternity. it will be a turning point as to whether we continue being a constitutional democracy or a dictatorship and an autocracy. I beseech you, do not let us go down the path of autocracy. And the privilege of your attention and your time. Unless you have any questions for me, I'll hand over to one of my colleagues. Thank you.
Thank you.
My Lord, my name is My Lord, my name is Kibe Mungai. The team leader is Paul Muite, Senior Counsel, assigned this application, the one from Kerogoya, to me, Professor Ogada, and Mr. Ndegwa Jiro. As I had already indicated to the court, and with the benefit of the submissions from my learned colleagues, we shall try to do our business within an hour. So I'll start first, followed by and then Mr. Ndegwa, for purposes of presenting that application. My Lord, let me start by thanking the court for the decisions that it rendered on last Friday. Questions of directions that it gave for the hearing of the petitions that are before the court. My Lord, I confirm that the process of amending the various petitions is ongoing and will be filed in accordance with the timelines fixed by the court. My Lord, going by the timelines that you gave, it is also my pleasure and appreciation, and that is in ensuring with the compliance with the Mutunga rules, that it is possible for your lordships to ensure that in the same way that the month of October we dealt with the political aspects, with the political phases of impeachment, that it is now possible, courtesy of your directions, to ensure that we can be able to have a judgment on merits for purposes of the various petitions that are before you. That would be an absolutely important issue for this court to remember, because it is being made as if it will not giving due process and ensuring substantive hearing of this matter, that we shall be here until forever. My Lord, all these businesses can actually be concluded within the month of November. That being the case, my Lord, by way of introduction, let me say two things in my own words as counsel representing, I believe, the 4th to 8th petitioners who filed the application that is before the court.
The date of your application?
Yes, my Lord, that is exactly the issue. 18. My Lord, 18, it is supported by an affidavit sworn by Honorable David Munyi Madenge on the same date. My Lord, for purposes of the documents, let me start there. We have filed submissions. The submissions were filed yesterday. There is a supplementary we filed today, and we have filed various responses to the affidavits to set aside that my learned colleague, Mr. Ogada, will be referring to them. My Lord, that being the case, I wanted to say that by way of an introduction, there are two broad issues that I can be able to say. My Lord, thank you. Yes. My Lord, the first issue is that moved the court applicants moved two of the constitutions. Every citizen of Kenya has an obligation to defend and protect the constitutions of Kenya. That's a broad mandate. And of course, further to the other mandate, that under the Bill of Rights, from Articles 19 to 23, where the Bill of Rights is being violated, they are permitted to come to this honorable court to seek for the appropriate reliefs. And therefore, that is the basis upon which they came and have moved this honorable court. My Lord, the second broad issue that I wish to cover at this particular stage is to point out that what is basically the big thing about the matters that are before you. My Lord, the big issue for purposes of the matters that are before you is that these impeachment proceedings, after you hear us, two possible scenarios are clear. The Deputy President, who has already argued his application, as his advocates has pointed out, is an elected Deputy President, an election that was conducted on the 9th of August, 2022. My Lord, on account of the vote of impeachment passed by the Senate on the 17th of August, 2024, if the process concludes in accordance to the manner in which it has so far been implemented under Article 149(1) of the Constitution, it would result into Kenya having an appointed president 2 years after one who is elected was put into office. My Lord, that's a big thing, whichever way you look at it, for the simple reason that one of the important devices of the 2010 Constitution was to ensure that the holders of President and Deputy President have the direct mandate of the people. So, in a matter where that important issue of our constitutions could change, it is our submissions that every absolute care must be taken to ensure that the process and the law leading to this very critical political and legal transformation on our constitution has been addressed. How would this be addressed? My Lord, we shall be arguing together with my learned colleagues that the only way in which this can be the hearing on merits of the petition that are before this court. My Lord, having given those introductory remarks, let me come to the application of the 18th by highlighting the issue that we both clearly know. My Lord, impeachment, and many cases, I will not go through them. The many cases that have been cited of impeachment shows that impeachment in Kenya has 4 processes. One, where allegations are made, that is purely political. Muduse went around, collected his evidence, presented. There was a motion, I believe, dated 29th of September, asking Parliament to have this 26th. I'm told 26th of September. That's the stage 1 of the political process. Stage 2 of the political process is the stage where the National Assembly approves by a vote of 2/3 of all the members to allow to reject the impeachment motion. My Lord, that was done. There are various issues that have been raised in the majority of the petitions that will be argued in the fullness of time that shows the significant problems when this matter was at the parliamentary level. Topmost of them being the impartiality of the Speaker and the Deputy, together with the manner in which public participation was handled. Stage 3, my lords, is the stage of the Senate. The law clearly talks about what the Senate should do, how the voting should be done, and again, there is evidence. My learned colleague, Mr. Ongoya, and Honorable Muite, they pointed out at the significant problems that we had there. I am most interested, my Lord, in the 4th phase. The 4th phase of impeachment, as it has now been established in our jurisprudence, is where these courts seeks to establish whether there was compliance with substantive law and procedural law by the political organs upon which the mandate of impeachment has been entrusted upon by the Constitution, other laws, and the respective standing orders. Again, my lords, that phase that where the court is supposed to deal with this issue, it is our submissions that this is the stage that this honorable court must ensure, because it is the court, that all aspects and proceedings are dealt with in a manner that we all had, and I'm happy for the time that the court has agreed to allocate us, so that the court, with sober minds, can be able to decide, have the laws of our countries been upheld or not. My lord, there are clear guidelines that have been set out by our constitutions for purposes of doing that. And my lord, because we are here because of an application for conservatory orders, under Article 159 of the Constitutions, this court has an express duty that in exercising the delegated judicial power of the people of Kenya, it is required, the certain guidelines have been given by the Constitution under Article 159, that is besides other provisions of the Constitutions. And one of the most important one is that, that the court will do substantive justice. Substantive justice is an important issue, and it has specific meaning through the very many decisions that have been rendered over time by the courts of this country. And the clear meaning in plain English, because it is important we understood in plain English. In plain English, it means a very simple things. That, for example, my lords, if we have a case of a goat, Mr. X and Mr. Y have a case of a goat, this goat should remain alive and should so that at the end of the decision, the court can decide whether it belongs to Mr. X or Mr. Y. That is the very simple meaning of substantive justice. So that, my lord, substantive justice, therefore, conservatory orders, is a mechanism that our laws preserves the goat. Our laws preserves the subject matter of the case. The subject matter of the case, my lord, is the questions of vacancy in the office of the president. Going by the Senate, the deputy president was impeached. On account of the orders that have been given, that office is yet to be filled. So that, my lord, the question, therefore, is easy to define and can be defined this way. That, as we wait for the hearing and determinations of this case, it cannot be settled at the interim level that the Honorable Kindiki will now be the Deputy President of Kenya, so that as we argue the petitions, there is already the impeachment process has been concluded to the disadvantage of the other people, of the other person who is seeking the same office. So that, my lord, is a simple issue that is very easy to define. So that, my lord, we shall be arguing that when we come to that particular issue, why on earth, because you have before you, because if a conservatory order is the legal mechanism, the legal device that is established by the constitutions to preserve the substratum of the matter, and for this court to do substantive justice, how on earth does the respondents expect that substantive justice will be possible if the trophy that is being tussled over, that is being contested over, is handed over to them? My lord, all systems of justice would be offended to be told that it is possible at halftime for one team to be declared to be the winner before the matches is concluded. Why can't we wait for all these issues to be concluded? It is a simple meaning of what substantive justice is all about, and the courts, the duties of the court to ensure that the ring is held even for all the parties, so that we do not argue over an academic matter. which would be the worst issues that can happen. My Lord, there is the case of the Gatirao Peter Munya. I'm coming to the applications for conservatory order. The principles are very clear. I just need to go on them as quickly as I'm able to. Under Gatirao Munya and other decisions, we have a big authorities, many authorities. The issues were set out very, very clearly. And there are three tests. The first test is on the prima facie case. My Lord, my learned colleagues have set out the various many legal issues that are there. That from the standpoint of the applications that we are arguing before you, there are 5 issues for purposes of the prima facie case to comply with the Gatirao Munya case. The first one, my Lord, is public participation. I don't need to go into that. It's a substantive issue in the majority of that issue. My Lord, the second issue is what we call the legality of the standing orders of the Senate. My Lord, in the petition filed in Kerugoya as 015, the petitioners, amongst other things, are saying that although the Constitution provided for clear timelines on how, for example, the business is going to be conducted, and specifically said that this investigative committee is the only committee that can be able to discharge that constitutional function, the Senate established standing orders under which the plenary of the Senate can also resolve that issue. The Constitution of Kenya does not provide for a mechanism on how the Senate can discharge that function. But it is very clear on how that investigating committee is supposed to conduct its business and how the right to hearing is to be given after a finding has been made that there is a case worth responding to. My Lord, I submit that's a big issue on the standing orders that were used to pass the vote of impeachment. The second issue that has been sought in that case is the issue of interpretation and application of those laws on impeachment, 44, all those laws, 48, 144, 144, 149, all those have been raised. My Lord, as you clearly know, this is the first impeachment for purposes of those laws. And therefore, if a question of interpretation has been raised specifically before you, it underscores the necessity to ensure that on merits, this court actually determines and interprets the law, so that the next time we have probably to do it against the president or against Kindiki if he gets there, the law would be clear and we shall not be going through all these things. So a serious issue has been raised by that petition. The other serious issues that have been raised is, of course, the fairness of the Senate proceedings. I will not go into that because already the lawyers for the deputy presidents have raised that issue. And the fifth important issue is the issues of nominations of the Honorable Kindiki. That issues of the nominations, my learned colleagues will say more about that. But as we wait for their turn to come, the only two issues that I need to say at this early stage is to point out the fact that under the constitutions, I believe Article 137 of the constitutions, any person occupying the office of the deputy president or the office of the president must be qualified in accordance with the constitutions of Kenya. Under the impeachment articles of the constitutions, these issues of the constitutions on the qualifications are not set out. So that because they are not set out, it is an assumption that when reading the Constitution holistically, this court will go to those other specific provisions of the constitutions where the issues of qualifications are set out. My lords, those issues of qualifications are many. One, and the body under the Constitution, my learned colleague Mr. Ndego will say more about it, is that the IEBC confirms whether any person has those qualifications or not. I don't think that is a contested issue. I believe it is also not a contested issue that at the time that the President of Kenya appears to have received some letter from IEBC confirming that the Honorable Kindiki is duly qualified to hold the positions of Deputy President, courtesy of Article 149 of the Constitution, we did not have IEBC. Of course, various arguments can be taken by the parties that are before you. Those arguments cannot be concluded. Those arguments can only be arguments to justify whether or not the conservative orders will remain in place or not. But they'll have to be settled when the petition has been heard. The second important issue on the aspect of the nomination of Kindiki that I need to point out is this, that even assuming the president did the right thing and everything else that he was doing, this court should be concerned by the fact that whilst the case was still going on before the Senate, the National Assembly scheduled a meeting by the National Assembly, which under Article 149 has 60 days, a meeting to occur the following day, within about 7 hours after the vote of the Senate. Why should this concern the court? It should concern the court for the simple reason that under Articles 10 and 118 of the Constitutions, Parliament cannot pass a law or make important decisions like approval of the Honorable Kindiki without engaging in public participation. The cases are so many for me to cite them. The jurisprudence is so clear for it to be disputed. So that, my Lord, the argument that we shall be putting on the issue of the nomination, unless this Honorable Court, that at this stage, that public participation does not apply to the nomination and approval by Parliament, then, my Lord, it is clear that this is the kind of case in which you are duty-bound to confirm the conservatory orders until this petition is heard and determined. Because the precondition would have to say, we have excluded this process from public participation. You would have to resolve the main issue, one of the main issues, at this stage before the petition has been heard. That would obviously be irregular. Now, none of us expect it to happen. I still wonder how the respondents would expect for them to get such kind of an order. I go to the second test, and this is the test of whether those orders will be rendered negatory. My Lord, again, I will not use the word no-brainer, but my Lord, this is not a difficult argument to be able to resolve. I had a little bit say something about it, but my Lord, the whole argument would be this, that if the whole argument, and that has been our case since we first came here last Tuesday, that we cannot, my Lord, be able to have a situation in which the petitioners are saying the constitutions of Kenya has been systematically violated, and that all these obsessions with the application to set aside the conservatory orders that are in place are meant to complete the violations of the constitutions. My Lord, under the constitutions, your first duty is to defend the constitution. That duty is particularly greater for the simple reason, it's called Meduse. The MP, Metuse, that one. When the mover of the motion had that duty under the constitutions, President of Kenya had that duty when conducting, making appointment under 149, National Assembly had that duty, and the Senate. But my Lord, you are saying, it says, the constitution has been, my Lord, the constitution has been violated. Then the duty that we do not turn this constitution into a hollow document is all the more greater. Park or whichever other place for them to say, we are swearing Kindiki. That would be a mockery of justice. But there is a greater mockery of justice that I would want to point out. Because this thing, and to break it down for the people, every order, in the normal litigations we do with every day, and you say somebody's rights are going to be violated. If somebody is saying I should not be hanged, I was not convicted properly by the High Court, if, my lord, that person is hanged before he has been heard by the Court of Appeal, clearly it would mean that the process of justice had not been completed, yet we have hanged the guy. My lord, in America, they keep on hanging people. Many of them terrible criminals, mass killers. But my lord, you will observe that at the time when we see these televised killings in America, it is always after they have exhausted judicial process, so that they are sure that process that are irreversible take place after legal benefit and protection has been accorded. One of those that is important, my lord, is captured under Article 27 of the Constitution, the right to protection of law. So that the issue, as long as I'm in court, the matter is not yet over. It might well be possible that we might lose this application, the interim application that is before the court. But we might also win it, and we are likely to win it. So that because, my lord, of that issue, that a person may actually succeed at the other stage is the reason why you prevent taking irreversible decisions. And, my lord, what is the scenario that we are talking here? My lord, with the scenario here we are talking about here is simple. Immediately after assuming the orders were lifted, that's the scenario I want to describe. What is it that is going to happen? My lord, we would have a scenario where the Chief Justice, whilst these proceedings are pending before the court, would have to preside over the swearing in of Honorable Kindiki.
To keep speculating about the swearing in of Professor Kindiki.
The issue of swearing in is
also, and he's referred to it 3 times now. This is the 4th time.
My lord, I believe that's the law. They have been saying they want to.
And my lord, whereas you
proceed then.
I was to ask my lord, what is the dispute before you? Is it the impeachment and whether it was lawful, or is it the nomination of the second interested party? Because
first of all, it's both, and I would want some protection for me to conclude so that we are all fair. They will have their time to respond, and I will not interfere with it. My lord, so that the important scenario that we must seek to avoid is a situation, and this is matter, it is also a matter both of the Constitution and statute law. My lord, the issue is that if we get ourselves into a situation in which the Honorable, the Chief Justice, might have to preside over the swearing in of Honorable Kindiki while this petition is pending, my lord, that, to borrow the words of Honorable, my friend Muigai, Senior Counsel, would be the greatest absurdity that we can encounter. Why is it an absurdity? It's an absurdity, my lord, for the simple reason, one of the authorities that we have cited is the assumption where, because of the experiences that this republic went through in the years 2007, 2008, specific laws had to be made to ensure that not only will this event be a public event. That's number one. But the more important issue from the standpoint of law is this, that before we get there, all legal disputes, contestations over the right to occupy that office would have been resolved. And my lord, that is the reason precisely why they say, after the Supreme Court has confirmed the validity of those 2 positions, then you do the swearing. My lord, it would amount to taking us back if that aspect, that rule of civilizations, were to be taken away on account of the setting aside of the conservatory orders that were issued, and for very good reasons, by your brother judges. I don't know whether there was a sister, by your brother judges. So that, my lord, the issue, as far as we are concerned, that is an absolutely important issue. We go to the next important issue, public interest. My lord, public interest has been defined in very many cases that are before you. And my lord, these public interest issues are just supposed to ensure that in administering justice, the court will do the right thing. Because we actually have a transformative Murugaro, Christopher Daradhi Murugaro versus Kenya Anti-Corruption. This I'm citing the passage appearing at page 7 to 8. My learned senior, Gedhu Muigai, will be familiar with this decision. My lord, from the last paragraph, what did the Court of Appeal say on public interest? I read, it said as follows. Lastly, before we leave the matter, Professor Muigai we understood him to be saying that the Kenyan public is very impatient with the fact that cases involving corruption or economic crimes hardly go on in the courts because of applications like the one we are dealing with. Our short answer to Professor Muigai is this. We recognize and are all aware of the fact that the public has a legitimate interest in seeing that a crime of whatever nature is detected, prosecuted, and adequately punished. But in our view, the Constitution of the Republic is a reflection of the supreme public interest, and its provision must be upheld by the courts, sometimes even to the annoyance of the public. The only institution charged with the duty to interpret the Constitution of the Republic and to enforce those provisions is the High Court, and where it is permissible with an appeal. We have said before, and we repeat it, the Kenyan nation has chosen the path of democracy. Our Constitution itself talks of what is justifiable in a democratic society. Democracy is often an inefficient and at times a messy system. A dictatorship, on the other hand, might be quite efficient and less messy. In a dictatorship, we could simply round up all those persons we suspect to be involved in corruptions and economic crimes and simply lock them up without much ado. That is not the path Kenya has taken. It has opted for the rule of law, and the rule of law implies due process. The courts must stick to that path, even if the public may, in any particular case, want a contrary thing, and even if those who are mighty and powerful might ignore the court's decisions. Occasionally, those who have been mighty and powerful are the ones who have run to seek the protections of the courts when the circumstances have changed. The courts must continue to give justice to all and sundry, irrespective of their status or former status. What orders should we make in the motion before us? So then, my lord, I make 3 points with regard to interest as understood by the Court of Appeal. Number 1 is that public interest means enforcement of the constitutions of Kenya. Secondly, my lord, to make the point from what we have cited, that the first duty of ensuring that you both protect the Constitution of Kenya and you protect public interest is vested in the High Court. Every other court above the High Court, the Court of Appeal, the Supreme Court, they can only do that on the basis that they are sitting in an appeal on a decision already made by the High Court. So that, my lord, it will be the submission that this reinforces the huge burden that this court must undertake. And my lord, the final issue that was being understood here is to say a constitutional democracy would not mean anything unless due process is upheld. And due process is the first duty of the High Court to ensure that in whatever dispute that is before the court, before it is decided, the court has confirmed due process has been observed, and as a constitutional democracy, that is a standard, because they try to compare ourselves with a dictatorship, that as a constitutional democracy, we can live with a decision. As my learned colleague, Mr. Ngoya, was saying, we cannot possibly live with a decision in which we would be seeing the Chief Justice, well, if that were to be the case, you would be seeing the Chief Justice swearing on Rapo Kindiki while we are arguing this matter before the court. So that the rules are clear, the rules do not require much elaboration on what they mean. And since that criterion of public interest has been made by the Supreme Court itself, my lord, I urge you to uphold it in the manner that will best ensure that the constitutions of Kenya and its dignity have been upheld. My lord, there is the question, so that I believe that we are very clear on public interest, except to emphasize that for the specifics of this case, what does the call of public interest require this court to do? It's a simple call, 5 quick things. Number 1, to confirm that the law on impeachment has been properly interpreted and applied. That's the first issue. To confirm that the laws on impeachment has been properly interpreted and applied. Number 2 is to achieve substantive justice for the parties, so that when a judgment will be issued by this court, at least everybody can win something, that nobody goes home with a hollow victory. That is the whole idea of substantive justice. The third issue is to determine that the issues of the violations of the constitutions is done while the matter is still alive before the court. My lord, very serious issues on Articles 27, 38, and 50 of the constitutions have been raised. They are all under the Bill of Rights. We urge that while public interest needs to be upheld by ensuring that when this court pronounces itself in a judgment, those issues would not have been turned into academic. Number 4, my lord, is to ensure that the integrity of the presidential or political succession that is written in express law under our constitution is not rendered ridiculous or ineffective. And in those, I point out what we had said earlier. The desire of the makers of the constitution was any person who will hold the office of deputy president and therefore can potentially become president without an election ought himself to be an elected official. So that it's a big thing if this office, and without good reason, except political, an appointed person. It is in public interest that an elected deputy president, except for the clearest of evidence, except for the greatest of sins that are clear to all men of justice, is not removed from office. My lord, the 5th issue is to do this, that this court protects the constitutions. I've already talked something about it, so I don't have to go much into it. My lord, there are only 2 decisions, before I sit down, that I would like to point myself to. There is the issues of Githongori versus Attorney General. It is one of the cases that are before you. The facts in Githongori are notorious, and they are also notorious for the simple reason that that decision, those old advocates who are there, Kina Paul Muite and Dr. Gibson Kamau Kuria, tells us that it was largely, though it was a 3-judge bench, it was written in the style of Chief Justice Madan. My lord, that issue said something that is important to me, the younger advocates in Kenya. And what it said is this: it emphasized the question of justice. And it emphasized the question of justice in the simplest meaning in plain English. You need to ensure everybody has a fair deal. This is to say that at the end of the day, everybody will leave the court and says, probably my advocate was not as good as I thought, but the judge did their best. But at the end of the day, let it be very clear that the court did everything that is possible to ensure that justice in its substantive form is achieved. This decision was rendered in 1984, long before the article on 159 was written, and that is why it is celebrated. And my Lord, it is also celebrated, and I am mentioning here for that reason, whenever honorable men, candidates before the Judicial Service Commissions are called upon to name whose jurisprudence has affected them, it is Justice Madan that is mentioned very many times. I will strive to be like Justice Madan. And my Lord, it is for good reason. All of us celebrate Justice Madan because he strived to do justice. But my Lord, in the same case, the older lawyers also told us about Alan Hancock's, about Dugdale, and even about Chunga. They tell us all these stories. But my Lord, in those interviews, I do not hear anybody saying I want to be like Alan Hancock's. So that, my Lord, I cite Madan in order to support the proposition that Judge Madan would never remove the conservatory orders that are before you, under the principles of doing justice and offering everybody a fair and square deal. The last case that I would want to cite, before I hand over to my learned colleagues, Professor Ogada, has he gone? Oh, I thought whether he has disappeared. My Lord, before I hand over to my learned colleague, is to point out to one little issue.
The petitioners, you have exhausted 2.5 hours. Budget how you are going to...
Yes, sir. Yes, my Lord, we are budgeting.
With the remaining,
yes,
no more than 30 minutes.
Yes,
anybody
my Lord,
who wants
understanding,
submit on your side,
yes,
we'll
try to do our best.
You have no more than 30 minutes.
Thank you. We'll do our best. My Lord, for purposes of this case, this is the only thing I'm citing before I go. This decision, like you've had very many other decisions on constituent power and everything, this will be an international decision. It's a decision that by universities across the country. And therefore, the least that I can do is to confirm that the lawyers for the petition are still familiarize themselves, as Macharia tried to do, with what other courts internationally have said. There is just like a small issue. On one of the most celebrated court, Justice Brandeis says as follows. This is important. Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. End of quote. I quote the words of Justice Brandeis in order to make the point that in the matters, the proceedings before this court, we have been treated to a scenario under which an impeachment process that, if you read the constitutions clearly, is a process that ought to be a legislative one, a process conducted by the legislative organs of the Kenyan state, has been converted into an all organs of government project. With the result, my Lord, that if the petitioners turns out to be right, you would then find ourselves in a situation whereby, like in BBI, this process of impeachment of the deputy president may end up being indicted as being a process that ended up being a government project, contrary to what was clearly spelled out by our laws. And my Lord, if it turns out that all laws were broken, and virtually out of the constitutions, I was counting them yesterday, it looks at 30 provisions of our constitutions have been seriously violated in the manner that this process has been undertaken, then we have a situations that Justice Brandeis had in mind when he talked about the government, which should be the lead in upholding the law, ends up being the principal breaker of the law, the principal violator of the constitutions. It is within your hands, your lordships and your lordships, to ensure that does not become our scenario. My Lord, Macharia, my colleague, emphasized something, but I want to finish by adding something. My Lord, in June 1982, when Kenya was legislated into saying that Kenya is a single-party state and KANU is the only legitimate organ, this was through a long process. Honorable Rengo, Honorable Muite, Gibson Kamau Kuria have told me the intricacies of the day, what actually. The month of October 2024, we have experienced events that the senior citizens of Kenya likened to the events of June 1982, when everything in Kenya suddenly changed. Kenya ended up to being it was a restricted democracy, but all the guardrails were removed after June 1982. Your Lordships, I urge you that if these petitions, if these proceedings end up in a manner that does not uphold our constitutions, then this constitution may face the same plight that the former constitution faced after the events of June 1982. We must hold and ensure the events of October 2024 remains regrettable and an aberration on Kenya's constitutional order, not the norm. My Lord, I am thankful for the time. My learned colleague, Mr. Ogada.
Thank you. How many people are yet to speak?
For these applications, there are two. I was with Mr. Ogada and Mr. Ndegwa. They have heard you when you talked about 30 minutes. They'll try to divide the time amongst themselves.
My Lord. Yes, my Lord, I was saying that we are also interested parties in the application and we would require 15 minutes.
We will reach you. Your time has not come.
Your Lordship, the presiding judge, Your Lordship, Justice Mrima, Your Ladyship, Justice Mugambi, I will be brief. A famous quotation says that while the legislature is the will of the majority, the court must always remain the conscience of society. That is the spirit of the Constitution 2010, and that spirit has been reiterated time and again by this court. Mine is two tasks before this court today. I will be going through a panoramic vista of the authorities before this court, and finally, I will go through the political question doctrine, something that has quite excited the other side, and to debunk the myth that the political question doctrine in any way applies in the context of the Constitution 2010. We are dealing here with an application for the preservation of conservatory orders, and insofar as the application in petition E15 is concerned in terms of prayer D and E, extension of those conservatory orders to cover the entirety of the proceedings pending judgment and determination. My senior colleagues have gone through the essence and the reasons why conservatory orders ought to be granted. Mine is just to buttress this, that I will add this court to look at the decision in David Ndii and others. That was a 5-judge bench decision led by Professor Justice Joel Ngugi, as he was And in paragraph 29 of their ruling, that is dated 26th February 2024, and in that decision, quoting a decision from the Supreme Court of Appeal in Nigeria, United Cement Company versus Dangote Industries, the court says that conservatory orders are prophylactic. They are intended to save the substratum of petitions. And as been ably demonstrated by my colleagues before me, we will sit at monumental oddity, the perfect storm in the teacup, when we allow certain processes to happen, including the swearing in of Professor Kithure Kindiki, who argued with me the BBI decision, that if his swearing in should go on, then these petitions will be rendered academic. That certainly should not be the legacy of this court. This court, in the context ably articulated by my learned senior, we have provided in our submissions to buttress what my learned senior, Mr. Kibe Mungai, has articulated in terms of the tests in Getirao Munya. We have the case of Kang'ethe Kinyanjui, the NOLAC case. These have been attached to a list of authorities. They express, in terms of fine legal distillation, what will mean by an arguable case. And in terms of that infamous term that was bandied here before, the term nugatory, it has been judicially defined. You look at what the Court of Appeal in Kang'ethe, Kinyanjui, and Nolek define nugatory to mean. In terms of public interest, we will invite these honorable courts whereby says that an additional limb to be examined is public interest. And we have labored in our submissions, Your Lordship, the presiding judge, to itemize 7 items of why the Constitution, as was articulated by my learned senior Ongoya, why the Constitution qualifies as the highest embodiment of public interest. We are here to argue for a conservatory order to issue as a prophylactic device to save the Constitution. That's our constant north. It should not be forgotten. Still on the question of public interest, my good friends representing the first petitioner have in their bundle of authorities 2 cases. The Court of Appeal decision in Matindi versus the Attorney General, 2023 EEKLR, the CAS case, famously called. And then we have the Ojo case, Ojo versus Agriculture and Food Authority and 8 others, 2024. I am reliably told that that was argued by my good friend, Professor Tom Ojenda, my senator, Queen's College alumni. And in that case, this is what the court said, in a nutshell, that we need to a nominee from public office so as to protect the Constitution, the integrity of the Constitution. Keep out that nominee. Let them not go into office. That is what we have been arguing. Ojo, Matindi, CS. Oh, I argued. Elisha Ngoya went through certain positions in law as contained in Justice Mrima's decision, Justice Mwongo's decision, your own decision. Those decisions are not idle. They are not mere words in English. They bear legal consequences by the virtue of the doctrine of judicial comity, that when a court declares itself on a position of law, and in the context of these particular petitions, we are dealing with collegiate decisions. Those decisions enjoy protection by virtue of the doctrine of judicial committee. Lord Justice Newberger, in an authority that we have supplied, the case of Willis and Joyce, 2016. This is the two 2018 appeal cases. We've provided that. Lord Newberger says this, that so far as the High Court is concerned, puisne judges are not technically bound by the decisions of their peers, but they should generally follow a decision of a court of coordinate jurisdiction unless there is a powerful reason for not doing so. That creates an honest presiding Mugambi, that the other side making those determinations for you to depart from the same. Elisha Ngoya, full picture of how odd that will be. We have also provided the case from the Supreme Court of the Parliamentary Service Commission versus Martin Nyaga Wambora. The court there examined decision-making and vacation of the same in the context of a collegiate court. The test has been given there by the Supreme Court. And what the Supreme Court says is that if this court might be tempted to reverse what has been made in terms of decision by a collegiate court, then the error has to be substantial. It has to be demonstrated. It does not simply amount to a question of mere allegation. It has to be shown demonstrably to the satisfaction of this court. I want to move quickly to the question of political question doctrine. My good friend, my brother, Mr. Gumbo, has spent a lot of ink, black and white, submitting on this. And he submitted to this court the authority of to him and those on that side who submit in that line of thinking, we say this, that the political question is an American constitutional emanation. It is a function of separation unique to the American constitutional context. That's number one. In the context of the Republic of Kenya, that morphed to mean justiciability. And in our context, it has yielded to notions such as ripeness, mootness. And this was done by no other than His Eminent Grace, the Lord Justice Mrema, in the case of Anthony Miano and others, was the Attorney General, 2020 EKLR. Thirdly, the political question focuses on limitation by courts, on the court restraining itself from dealing with matters within the responsibility of the political arms of government. Now, in terms of the US context, and I have said that Mr. Gumbo has submitted on this case, and we wish to respond to him. This is what they did not tell you in terms of Baker versus Carr. Baker versus Carr, 1962, lays down 6 factors that can be used in identifying what a political question is. So the political question within the American context is not a general rule of application. It is applicable, yes, but within certain parameters. And the context in which that political doctrine question principle can be used is where, number one, there is lack of a judicially discoverable and manageable standards for resolving the dispute. In other words, the judiciary does not have the wherewithal to deal with that question. Number two, the impossibility of deciding the dispute without being to the detriment of a political policy determination that has been made. Number three, the impossibility of the court undertaking such independent resolution without expressing a lack of respect to government, the political branches. Number four, the unusual need for unquestioning adherence to a political decision already made. Number five, the potential embarrassment and textually demonstrable commitment to the issue of a coordinated political department. Those are the 6 circumstances according to Baker versus Carr. So the question, Your Lordship, Presiding Judge, what will be the usefulness of this doctrine in Kenya? The Constitution of the Republic of Kenya, David Ndii and others, the Constitution of Kenya has an internal theory. As Elisha Ngoya articulated, and as was articulated in BBI, the Constitution is a transformative Constitution, such that our tenor, our tone in terms of Constitution is radically different from the American. From the text of our Constitution, this is what the Court of Appeal in the BBI decision said at paragraph 139 and at paragraph 144. At paragraph 139, the Court of Appeal said that the Superior Court, being this court, by virtue of Article 22.1, 23.1, and 258.1 of the Constitution, had jurisdiction to complete and incomplete breaches of the Constitution. Your Ladyship, Your Lordships, the substratum in the BBI case was a bill that was stopped in its track before signature. That is important in terms of this context. At paragraph 144, this is what the Court of Appeal says, that when matters involve a threat to breach constitutional rights, justiciability requirements are satisfied and hence the court is allotted. The court is seized with jurisdiction when a breach of the Constitution. Constitutional texts, plain reading. Article 4.1 read with Article 4.2 together with Article 1 provide an interface between law and politics. I repeat, 4.1, 4.2 as read with Article 1 provide an interface between law and politics. The requisite of power ultima, sovereignty in the people, and the requirement by the Constitution that government and governance must be in accordance with the Constitution, Article 2.1, our supremacy clause, ensures that politics are subordinated to the rule of law and constitutionalism. Article 3, the preservation clause. Everybody is enjoined to defend the Constitution. And that provision has normative significance in establishing a legal and moral commitment to uphold and protect, defend the Constitution. Article 3.2, an attempt to establish government, including appointments, otherwise than in conformity with the Constitution, is unlawful and unconstitutional. Article 2, Subarticle 2, no person may claim or exercise state authority except as provided under the Constitution. In conclusion, Your Lordships, Your Ladyship, in an old story, and it's probably even true, when the authors of the American Constitution declared after months of work in Philadelphia that they finally reached consensus, a lady by the name Mrs. Powell shouted a question to the revered Benjamin Franklin, an American statesman, who was then 81 years old. And this is what Mrs. Powell told Benjamin Franklin. Dr. Franklin, what have you given to us? A monarchy or a republic? And this is what, Your Lordship, Your Ladyship, Dr. Franklin answered the lady. A republic, if you can keep it, the judiciary must stand as the unyielding guardian of the Constitution, the pillars of justice and democracy begin to crumble. I submit. Thank you.
Thank you. Bananjeru,
Yes, my lady, my lords.
how are you?
I'm well, my lords.
You have 10 minutes.
My lord, I'll try to do the best within the time allocated.
All right.
My lord, my lady, my lords, permit me to join issues with the earlier submissions made by my learned friends. And permit me, my ladies, my lords, to submit that my submissions will majorly
Issues is on the same side. Join issues. We haven't submitted.
What problem do you have with that, Professor Gender?
My lord, join issues means he's on the opposing side, but he's supporting the applications as framed. So I don't know whether it is simply a question of not knowing that we haven't spoken, perhaps. He's running low on sugar.
My lord, the presiding judge, you made an important point that we are Africans.
I think let Njiru proceed.
and he will have his time to speak the right English when his time comes. My ladies, my lords, my submissions will deal with the aspects of public interest in respect to the reason why the court must sustain the conservatory orders as granted by his Justice Mongo and Justice Mwita. Your Lordship, permit me to begin by drawing your attention to the dictates of Article 3, which requires every person to uphold and protect the Constitution from being violated. My lady, my lords, the Constitution that we are here to protect this afternoon is a document that is progressive in nature and that seeks to protect individuals who either serves in government or out government in whatsoever organ. My lords, in my address, I'll majorly deal with the question of the purported nomination of Professor Kithure Kindiki and whether the lifting of the conservatory orders will culminate into his swearing in and what that means in respect to the provisions of the Constitution. My ladies, my lord, it is clear that a purported process took place in Parliament that culminated into a name being forwarded to Parliament for voting. My ladies, my lords, it is important for us to interrogate the circumstances that led to the forwarding of this name, and whether or not that process is confirmed with the dictates of the Constitution. My ladies, my lords, on the 18th of October, we walked towards what friend Mr. Ongoya submitted on a memorandum by the President. The said memorandum, my ladies, my lords, that the President from the independent and the answer was sufficient enough to afford him the courage to forward the name for voting in Parliament. The question begs and is, did the IBC possess the requisite constitutional capacity to submit or approve the said name for purposes of voting in Parliament? My ladies, my lords, the answer to that will be found in Article 88, as read together with Article 99 and Article 137 of the Constitution. Article 88, my ladies, my lords, creates the Electoral and Boundary Commission. And in the same article, my ladies, my lords, creates the functions of the said commission. You'll also find the same answer, my ladies, my lords, in the amended IBC Act. Most importantly, Section 10 and Section 11, which I'll be dealing with in the near future. My ladies, my lords, Article 99, as read together with Article 137, provides the qualifications for an individual to hold the office of the president, and by extension, the office of the deputy president. It is important to note, my ladies, my lords, that in the event anything happens and the current president is incapable of office of the president, the purported name, if sworn in, will be the person to take over. Necessary requisite qualifications, and that these qualifications are met. My ladies, my lords, that the constitutional organ judicial notice, my ladies, my lord, that the commission as currently constituted falls lack of the commissioners. And the question, therefore, my ladies, my lords, in the event to evaluate the qualifications under Article 99 and Article 139, can be submitted in Parliament for voting. Who then is capable of doing that in the absence of the commissioners? My ladies, my lords, we submit that IBC, as currently constituted, can only execute administrative functions, and it has no capacity or ability to execute the function under Article 99 as read together with Article 137 of the Constitution. My ladies, my lords, the Constitution as read together with the IBC Act has created distinct functions that for the commissioners and the secretariat. And you'll find that, my ladies, my lords, in the decision, consolidated petition number 305, which was between Engineer Mwaura Kamau, Charity Kalukingilu versus EACC. A three-page judge, my ladies, my lords, had that to consider whether the secretariat, in the absence of the commissioners, can take the functions designated and exclusively allocated to the commissioners. My ladies, my lords, at paragraph 347, this is what the court had to say. From the foregoing provisions, it is clear to us beyond that the membership of the Constitutional Commission is between 3 and 9 members. In other words, the composition of the Constitutional Commission ought not be less than 3 and not more than 9. The court goes on to say that if the secretariat, and in this case, the CEO to the IBC, would then be seen to execute the functions of the commission, it would then mean that the commissions would go beyond the constitutional dictated number of either 3 or 9. The court said at paragraph 348, the said members, otherwise known as the commissioners, are empowered to appoint the commission's chief executive, known as the secretary. To contend that the secretary, who is an appointee of the commission, is part of the commission would mean that the commission would, where commissioners are 9, be composed of membership of 10. The court said one only needs to mention how ridiculous this argument is. It is therefore our submissions, my ladies and lords, that the name that was submitted to Parliament is not capable of replacing, in the event this court dismisses our petition and upholds the impeachment, the Deputy President of the Republic of Kenya. The court further said at paragraph 353, I refer the court to have a look at paragraph 353 and paragraph 354. But of the most importance is what the court said relied in the case of petition number 46 of 201. The court relied in a Ugandan case, and this is what the court said. It is clear to us that under the Constitution and under the legislations, the foundation of the power of a secretariat is the existence of the commission. The secretary and the secretariat can only carry out the powers vested in their offices when the commission is in place, exercising its powers since they implement what the commission has approved or resolved. Again, I urge the court to look at paragraph 356 and also 358. But most importantly, your Lord, my ladies, my lord, is what the court is saying at paragraph 362. This is what the court had to say. We therefore also agree with the petitioners that any decisions purportedly transmitted to the DPP recommending the prosecution of the petitioners without the sanction of the commission would not be in compliance with the law and the Constitution. We urge you, my ladies, my lords, to find that the name that was submitted in Parliament is not capable of replacing the Deputy President of the Republic of Kenya. Why is that important, my ladies, my lords? Because if the orders are lifted today, that will be the next course of action.
My lord, that's not a finding you can make in your ruling on an interlocutory application.
Well, why, my ladies, my lords? Because this is a train with many compartments and many stopovers. The next stopover that we shall land on, my ladies, my lords, if the orders are lifted, is to have a person who was not duly appointed in accordance with the Constitution taking over the office of the Deputy President. My ladies, my lords, permit me to draw your attention to paragraph 365, 336, and 337 of the same judgment. And this will be my final submissions in respect to this judgment. At paragraph 367, the court is saying, whereas a commission may be disabled in its ability to perform its functions, such disability does not automatically render the commission extinct. Such an event, in our view, only places the commission in a state of dormancy as it is able to carry out its functions. My ladies, my lords, I have perused the replying affidavit filed by Marjan on behalf of the IBC. He makes no reference to the memorandum filed by the President. My ladies, my lords, he technically makes sure that he does not make reference to that so that he may not be seen as if he has delved into the functions of another organ. My ladies, my lords, permit me to draw your attentions to section 6 of the appointment, I beg your pardon. Paragraph 6 of public appointment parliamentary approvals. And as you look at paragraph 6, also look at the definitions contained at paragraph 2 of the same act. What an appointment means and what a candidate means. And for avoidance of doubt, a candidate means a person who has been proposed or nominated for appointment to a public office. Section 6 creates the criteria upon which Parliament must follow so as to satisfy the need for public participation. It also creates the time in which to be executed. It has been submitted that this was supersonic speed that took approximately 6 hours, and the Republic of Kenya had a new deputy president proposed. But the question might be, can this be done in the absence of the exercise of the sovereignty of the people of Kenya? If we were to allow this, my ladies, my lords, what will be the import and what will be left of Article 1 of the Constitution? Will it be to mean that Article 1
Bye-bye to FOMO, the fear of missing out, by downloading the KBC Online app that gives you access to everything you love. Get the latest news, sports, music, entertainment news, live TV, live radio, and so much more at the palm of your hands. To get the app, simply search KBC Mobile Digital app in your Google Play or App Store and download the app. Catch what you want, anytime, anywhere. Stay connected. Stay ahead with KBC Mobile Digital app.
Friday night again.
Greetings in the name of the Most High Jah Rastafari. My good name is Marley Moses, the Positive Warrior, alongside.
Yes, sir, DJ D-Rage, the baddest. Each and every Wednesday from